Hey guys, welcome back to the channel. This is the House of Law and I am Attorney Al Jumrani. This is episode 3 of Civil Law Jurisprudence by Justice Leonen. If you missed the second episode, you can watch it through the link above or the link in the description box below. In this episode, I will talk about 3 more Supreme Court decisions penned by Justice Marvick Leonen. The first case is about novation of contracts, the second case is about compromise agreements, and the third case is about delegation of already delegated powers. Let's begin. Our first case is Arco Pulp and Paper Company Incorporated versus Dan T. Lim, GR number 206806, June 25, 2014. In this case, Dan Lim, who was in the business of supplying scrap papers, cartons, and other raw materials, delivered scrap papers worth over 7 million pesos to Arco Pulp and Paper Company Incorporated. The parties agreed that Arco Pulp would either pay Dan Lim the value of the scrap papers or to deliver to him Arco Pulp's finished products of equivalent value. On April 18, 2007, Arco Pulp issued a post-dated check in the amount of 1,487,766.68 as down payment. On the same date, Arco Pulp and a certain Eric C. executed a memorandum of agreement where Arco Pulp would deliver its finished products to Eric C. According to their memorandum, the raw materials would be supplied or sourced from Dan Lim. Meanwhile, the post-dated check, remember, which Arco Pulp issued to Dan Lim, was dishonored by the bank for being drawn against a closed account. Arco Pulp refused to pay despite demand, so Dan Lim sued for sum of money. The regional trial court, however, dismissed the complaint, holding that when Arco Pulp and Eric C. entered into the memorandum of agreement in which Arco Pulp would deliver finished paper products using Dan Lim's raw materials, novation had taken place. Ergo, Dan Lim should have collected from Eric C. So, what is novation? Was there really a novation in this case? Applying civil code provisions, the Supreme Court defined novation as a mode of extinguishing an obligation by changing its objects or principal obligations, by substituting a debtor in the place of the old one, or by subrogating a third person to the rights of the creditor. For novation to take place, the following requisites must concur. First, there must be a previous valid obligation. Second, the parties concerned must agree to a new contract. Third, the old contract must be extinguished. And fourth, there must be a valid new contract. In this case, Dan Lim was not privy or a party to the memorandum of agreement between Arco Pulp and Eric C. If the memorandum of agreement was intended to novate the original agreement between the parties, respondent must have first agreed to the substitution of Eric C. as his new debtor. The memorandum of agreement must also state in clear and unequivocal terms that it has replaced the original obligation of petitioner Arco Pulp to respondent. Neither of these circumstances is present in this case. Thus, Arco Pulp's obligation to Dan Lim still subsisted. Arco Pulp was ordered to pay. Parang yung viral na food package sa Cebu. Imo nang gikaon, bayari sad uy. The second case is Nestor T. Gadrinab versus Nora T. Salamanca et al. GR number 194560, June 11, 2014. Here, petitioner and respondents are close relatives and heirs of the late spouses Nicolas and Aurelia Talao. The late spouses had left a parcel of land in Santa Ana, Manila. The heirs filed an action for partition of the property but later agreed to just sell the inherited property and divide the proceeds of the sale into 4 parts. Nestor, the petitioner in this case, was occupying half of the property. The heirs submitted to the court a compromise agreement, among the conditions of which was for Nestor to vacate the property after the payment of the share belonging to his father. The compromise agreement was approved by the court and the judgment based on the compromise agreement became final and executory. After some time, Nestor filed a motion for execution because he did not receive the share that was to be given to him. Apparently, the other heirs were stalling and delaying the sale of the property. This only led to conflict among the heirs. Thus, out of frustration, the other heirs moved to just proceed with the original intention of physically partitioning the property. The regional trial court granted the motion for physical partition. On appeal to the Court of Appeals, the Court of Appeals affirmed the trial court, holding that this was an exception to the immutability of judgments because circumstances transpired after the finality of the decision, rendering its execution unjust and inequitable. So the issue in this case is whether the courts erred in allowing the physical partition of the property despite finality of a previous judgment based on a compromise agreement involving the sale of the same property and the division of its proceeds. To this, the Supreme Court ruled, "Witchels na, wala nang bawian." In a compromise agreement, the parties freely enter into stipulations. A judgment based on a compromise agreement is a judgment on the merits of the case. It has the effect of res judicata. Applying Article 2038 in relation to Article 1330 of the Civil Code, a compromise may only be annulled if the consent was given through mistake, violence, intimidation, undue influence, or fraud. In this case, there was no issue as to the fact that the parties freely entered into the compromise agreement. There was also no dispute about the clarity of its terms. Some of the parties simply do not wish to abide by the compromise agreement's terms. Courts cannot relieve parties from their obligations simply because the agreements are unwise. The mere fact that the compromise agreement favors one party does not render it invalid. Courts cannot have the power to alter contracts in order to save one party. Our third and last case for this episode is Fuji Television Network versus Arlene Espiritu, GR number 204944-45, December 3, 2014. In this case, Arlene Espiritu was hired from 2005 to 2009 by Fuji Television Network, a Japanese company, as a correspondent producer at Fuji's Manila Bureau Field Office here in Manila. Fuji terminated her services in May 2009 on the ground of her having been diagnosed with lung cancer. According to Fuji, it would be difficult for her to perform her job. Thus, she was made to sign a resignation letter. Subsequently, Arlene filed a complaint for illegal dismissal against Fuji. Both the NLRC and the Court of Appeals found that there was illegal dismissal. Hence, Fuji was ordered to reinstate Arlene, pay her back wages, and other monetary benefits. Then, Fuji appealed to the Supreme Court. Arlene opposed the appeal both on substantive and technical grounds. On the technical ground, Arlene claimed that the petition was signed by Juan Corazon Asarden. Her special power of attorney, however, was signed only by Mr. Shuji Yano and not by the Board of Directors of Fuji Television. It appears that a board resolution was issued authorizing Shoji Yano and a Mr. Jin Eto only to represent and sign for and on behalf of Fuji Television. So the issue here is whether a delegation of power can further be delegated. To this, the Supreme Court ruled in the affirmative. Article 1892 of the Civil Code provides that the agent may appoint a substitute if the principal has not prohibited him from doing so. In this case, Shuji Yano was an authorized agent or representative of Fuji. The Secretary's certificate does not state that Shuji Yano is prohibited from appointing a substitute. In fact, he is empowered to do acts that will aid in the resolution of this case. So, alam nyo na ha, kapag ikaw ay binigyan ng autoridad na kumatawan sa isang tao para mag-asikaso ng isang bagay, pwede mo ipagawa sa iba yan, lalo na pag tinatamad ka. Joke lang. The point here is delegation of power can be further delegated if there is no express prohibition against it. Alright guys, that's it for episode 3 of Civil Law Jurisprudence by Justice Leonen. I hope may natutunan kayo today. For the bar reviews, take note of these cases. They might come out in the bar exams this November. Please drop a like if you like this video. Please subscribe to support me and click that notification bell to be alerted when I upload a new video. So till next video, laging tatandaan, isip ay buksan, alamin ang batas. Bye guys!